The Chevron Doctrine was a platform for government tyranny and abuse. Why the Supreme Court was right in overruling the Chevron Doctrine. The Supreme Court of the United States has recently overruled the landmark Chevron deference. By a vote of 6-3, the justices overruled the 1984 decision in Chevron v. Natural Resources Defense Council, which gave rise to the doctrine known as the Chevron Doctrine. To understand what this means, we need to explain the Chevron deference or Chevron Doctrine. Cornell Law's website explains it this way. One of the most important principles in administrative law, the Chevron deference was coined after a landmark case, Chevron U.S.A. Inc. v. Natural Resources Defense Council Incorporated, 468 U.S. 837, 1984. The Chevron deference is referring to the doctrine of judicial deference given to administrative actions. In Chevron, the Supreme Court set forth a legal test as to when the court should defer to the agency's answer or interpretation, holding that such judicial deference is appropriate where the agency's answer was not unreasonable, so long as Congress had not spoken directly to the precise issue at question. Let's explain that in plain language. Congress passes a lot of laws. GovTrack.us says that since World War II, the earliest we have data, Congress has typically enacted 4 to 6 million words of new law in each 2-year Congress. For comparison purposes, the King James Bible has about 730,000 words. Is that a problem? Well, there are those who think Congress passes too many laws, but that is not the subject of this article. The issue with laws passed by Congress is many of the laws that are passed are vague or rely on further interpretation by some government agency to figure out what the law really means, what rules and regulations are needed to make the law work, and what enforcement systems will be needed to ensure citizens and businesses comply with the law. A good example is the Jumpstart Our Business Startups Act, or JOBS Act, which was signed into law by President Obama on April 5, 2012. This act included something we know as crowdfunding, a way for small businesses to raise small amounts of capital without the heavy-handed regulatory compliance faced by larger companies under Securities and Exchange Act regulations. However, it took the SEC 4 years to figure out all the rules and regulations needed to make regulation crowdfunding, or Reg CF, work. It only went into effect on May 16, 2016. When you think about it, this system seems logical and rational. The bills passed by Congress are already long and complicated, but no law, like setting up a crowdfunding system, could include every minor rule and regulation. So some of it is left to the determination of the administrators who administer the law and enforce compliance. These administrators are government agencies like the Security and Exchange Commission, the Environmental Protection Agency, and the Department of Homeland Security. Each of these agencies is filled with experts who understand the existing rules and regulations, who in many cases were involved in helping write the new laws, and who one would think are best suited to develop the new rules and regulations needed to comply with the new laws passed by Congress. Further, these experts associate with and know of people who are not members of government, but who are also subject matter experts, such as consultants, scientists, attorneys, accountants, business people, and professors. The Chevron Doctrine says that rather than make an informed decision on a case in front of the court by referencing the legislation passed by Congress, the court will instead side with the government experts and their interpretation of the legislation passed by Congress. In theory, which sounds reasonable, but is it? Let's look at how government agencies and bureaucrats work. Most government agencies follow a doctrine of spend plus budgeting. That means if the agency spent $100 million last year, they would ask for $110 million for the next year. If they ask for $110 million and they're given $105 million, they call that cuts to the budget, as if they are cutting their spending. Now, if that agency gets another $10 million, what must it do? It must spend that money. How does a government agency spend money? Creating more rules and regulations and enforcing those rules and regulations. So, it is possible, some would say probable, the agency will take the widest interpretation of a legislation to generate more funding to create more rules and regulations. In many government agencies, the compensation and power base of management is based in part on size. My state-run school is an example. Student enrollment factors into the compensation of deans, provosts, and presidents. The incentive then is to increase enrollment, which can be accomplished by lowering standards to admit more students, and by encouraging part-time students to increase their course load by taking more classes. It is not uncommon at my university to find a student who has a full-time job carrying a course load of 15 or even 18 units. Again, bureaucrats may, and some would suggest will, take actions that build the organization as a way of increasing their own compensation and power base. And those actions often involve an increase in rules, regulations, and oversight. People and organizations tend to champion the cause. What I mean by that is people working in an organization tend to make decisions and take actions that increase the objective of the organization as opposed to questioning it. People who work at McDonald's want to sell more burgers. People who work at Samsung want to sell more phones. People who work on dairy farms want to sell more milk. People who work in government agencies want to create more rules and regulations and catch more people and businesses who are not complying with those rules and regulations. Just as the people at McDonald's are not asking, should we sell people more burgers? The people in government agencies are not asking, should we reduce or eliminate any of our rules or regulations? So even if the rules and regulations are not really aligned with the legislation, no one in the government agency is ever questioning that because the purpose is to fulfill the mission. The Chevron Doctrine defers to the government because it assumes the government has access to experts or are experts. But does reliance on experts make sense? We know that over the years, very well-intended experts have been wrong. Experts said we would run out of food. We didn't. Experts said we would run out of oil. We didn't. Experts said acid rain would kill all of us. It didn't. Experts said we would all die from AIDS. We didn't. Experts said if you wear a mask, you won't get COVID. It didn't work. Experts said if you got a vaccine, you would not get COVID. Not true. And of course, the list goes on and on. Experts are fallible. Why are experts fallible? For numerous reasons. Like everyone, they make mistakes. Often, they are so vested in their own area of expertise, they cannot see the bigger picture, like the New York government who said during COVID, bankrupting thousands of businesses and putting millions of people out of work was worth it, as long as it saved one life. Many people, including me, would disagree. Further, experts are not always honest. We have accountants who cook the books, politicians who take bribes, doctors who oversubscribe drugs, and scientists who take kickbacks. To summarize, in government agencies, the stage is set for government experts to make decisions that very well could be in their own self-interest to build their power base, increase the size of their budget, to increase their compensation, or to fuel their personal mission. Or those experts might not be able to see the bigger picture, or they might be dishonest. All these reasons are very real reasons why there needs to be some monitoring factor to make sure the experts are making the best decisions. That monitoring factor is the Supreme Court. The Supreme Court does not make laws. The Supreme Court reviews the laws, but also plays an important role in monitoring the rules and regulations that government agencies create to enforce those laws. To defer to the government as the experts is like asking the fox to guard the henhouse. For all the reasons discussed, the experts are no different than anyone else. They are subject to the traits of human nature, which means self-interest, dishonesty, lust for power, personal gain, personal beliefs, and even their own moral and ethical may influence their actions, and as history has shown us, often does. What is the purpose of the Supreme Court? Justitia. Com tells us that the Supreme Court serves the critical function of protecting minority populations against laws passed by majorities that could infringe on their rights. This allows it to preserve fundamental American values at times when a popular majority may try to deviate from them. The court also enforces the separation of powers and constitutional checks and balances by invalidating actions by the executive and legislative branches that exceed their powers. Through its appellate jurisdiction, it serves as the court of last resort for parties appealing decisions from lower courts. Decisions by the Supreme Court are final and may not be appealed further. Notice that one of its prime functions is constitutional checks and balances by invalidation actions by the executive and legislative branches that exceed their powers. How possible could they perform that function if they use the Chevron Doctrine to allow government agencies to do whatever they want, based on experts? Now, there are those who would suggest that the Supreme Court may have its own biases. If the majority is conservative, the rulings may be conservative. If the majority is progressive leftist, the rulings may be progressive leftist. We would hope the justices would leave their political inclinations out of the decision-making process and focus on the Constitution, precedent, and common sense. But even if they make a ruling that some don't believe is fair, our system allows the matter to be brought before the court again. Much has happened with the Chevron Doctrine. So, there are checks and balances against the Supreme Court. On the other hand, if the Supreme Court defers to government agencies, there then are no checks and balances on those government agencies. Historically, the decision may not have made much difference. Even back in 1984, government interference and regulations of our daily lives and business activities were still tolerable. Today, the circumstances are different. Today, the government is a behemoth of complex rules and regulations that control and interfere with much of our daily and business lives, and the trend only gets worse. The government will abuse its power, is abusing its power, and many people and organizations with power ultimate do. The government we have today is certainly not the one envisioned by our founding fathers. The only check on that abuse of power by the government is the Supreme Court. And given what is going on today, we need those checks to constrain government more than ever.